Hello and good afternoon and good morning or evening to all of you, and welcome to today's webinar on a new eco-social contract, the case of Nepal and Chile. And this is part of the activities of the Global Research and Action Network for a New Eco-Social Contract that is kind of co-organized by the Green Economy Coalition and UNREST with many partners around the world. The network has at the moment over 160 participants. And today I'm very happy to have here some very prominent practitioners with us, because what can be more of a vision than a constitution with regard to new eco-social contracts? I think it's really kind of the pure form of a new social and ecological contract is a constitution. And we have here two very interesting cases. The case of Nepal. As many of you will know, Nepal adopted a new constitution as a response to social movements, the civil war, and the demand of having a new social and ecological system that replaced the monarchy in Nepal. And then we also have the case of Chile, which also after 2 or 3 years of kind of social protests coming from different parts of society, had decided to replace the Pinochet dictatorship constitution with a new constitution to reflect the vision and for a new society that would be more democratic, more egalitarian, and also have a very strong ecological vision, including large parts of society. So we really would like to look today at these two examples. So the Nepalese, which have adopted a new constitution, and then have a look, what does it mean? What were the roles of civil society movements? And also what are the implementation challenges? And then also looking at Chile, because unfortunately the draft constitution was rejected by 62% of the population in September of this year. So to look at, what were the backlashes, what were the kind of arguments, problems, and what will be the way forward. So we are very happy to have here 3 practitioners, Alina Sava, whom I will present in a moment because she will be our first speaker. And then Justice Bhattarai from the Supreme Court of Nepal, and Pedro Cisterna, who works for Nuestra America Verde and many other kind of global, regional, and national initiatives on climate and ecology. So really welcome to the panelists, and a welcome also to the participants. I see we are already over 60 participants, so I think it shows the interest in this topic. And I'm very happy to start with Alina. Alina is part of the Global Research and Action Network, and she has written together with Gabriele Köhler, another network member, a paper on the role of rights-based civil society activism for new eco-social contracts and they are looking at the example and experiences of Nepal and the constitution making in Nepal. So Alina, you are an indigenous activist from Nepal, but you also work for an international human rights organization called the Center for Economic and Social Rights. And you have also been representing indigenous peoples in many international fora, such as CCC and the UN Permanent Forum for Indigenous Peoples. You have a master's degree in politics and public policy from the University of Sheffield. And as I said, you're also a member of the National Indigenous Women's Forum. So really welcome to you, and we're looking forward to hearing more about the paper. Thank you so much. You have the floor.
Thank you, dear Isabel, for your kind introduction. Hello to everyone, and hello to all the panelists. To start with, so I will be presenting briefly on the paper towards a new eco-social contract, the key roles of civil society in Nepal establishing the eco-social contract, which I have co-authored with my colleague Gabriele Köhler, who is in the audience here. here listening to the webinar. So, but today I was asked to speak specifically with a more focus on role of civil societies of marginalized people, indigenous people, Dalit rights movement, women's movement in making the constitution of Nepal. So before deep diving into that answer of that question, first I'll try to set a context of where this but this process of constitution building process in Nepal and the process of having a social inclusion and rights of marginalized people. So it all began since the end of civil conflict, 10 years long civil conflict in Nepal in 2006. And since then, coming to 2015, it's almost 10-year long process of constitution writing. And it was not an easy process because we have had two constitution making elections. So you can imagine the different interests of different people, the conflict, the social movements coming together to make the 2015 constitution happen in September 2015. Yes, it's a very progressive constitution, as argued, and it has elements of progressive constitutions. For example, legally, it has enshrined social inclusion as one of the fundamental aspects in the constitution. Nepal moved from being a unitary monarchy to federal state. There is more proportional inclusive rights granted to women, indigenous people, Dalits. But my key arguments today would be, well, constitution being the legal key entity or fundamental policy, legal policy, is it enough to address the aspirations and demands of marginalized people in Nepal who had been since long time demanding for social inclusion, for equality, for social justice? And in that sense, what was the process like, and what are the civil society's role, both during the constitution making process and in the period of implementation, because it's still a very young constitution. To understand that, we need to first understand the concept of marginalized people in Nepal. The key group are women, Dalit, indigenous peoples, and Madhesi communities. To give more context on that, they reside on the southern plain of Nepal and are marginalized regional marginalization, whereas Dalit and indigenous people face marginalized mostly on base of religion and caste systems. There are also Dalit in the Madhesi community and big chunk of women's group in Nepal. Facing marginalization in lens of gender. To understand for now, let's take it in that way. So the elements, the progressive elements of constitution in Nepal was, as I discussed before, whereas since the adoption of constitution, the process was rife with violent conflict, both peaceful and violent conflict. Largely indigenous movement, Dalit movements, and Madhesi movement considered the constitution is not it's not enough to address the exclusion they have been facing. So during the adoption of constitution in September 2015, there were 40 people died during the protests against the constitution, whereas there was other part of the Nepali group like considering it's one of the progressive constitutions. So it gives how polarized and how diverse Nepali society is, whereas there are people being killed in global southern region of the country, whereas largely the urban population centered in Kathmandu celebrating the constitution. The next thing, so I would like to go through what we achieve in constitutions in major three key areas of social, economic, policy reform, political reform, and political gender reform and environmental reform. So social inclusion is not a new concept to Nepal because it has a long history of social assistance program. For example, old age pensions, single women pensions, etc. But it was more, it was not much in a larger spectrum. For example, the case of underfunding and things were the issue. But since social inclusion being the fundamental part of the new constitution, obviously it will have larger advantage, and also will gather more diverse group into some of the social economic reforms. For example, some of the example that happened after the adaptation of constitution was employment program, mostly focused to the youth, called Prime Minister Employment Program, free access to health services to disabled, single women, etc. Although the limitations of these programs can be topic for another discussion, but the inclusive programs became like more diverse and much larger in scope. And in political reform, Nepal achieved a lot from the new constitution making process, because the civil society group, including of the marginalized people of Dalit, Amadesi, and indigenous people, considered the constitution making process as one of the political opportunity. That is the watershed moment. That was the watershed moment for the moment, because they thought, this is it. This is the opportunity. We have to take it if we want to instrumentalize our rights in constitutions. And that was not easy, because, as I mentioned earlier, it saw a lot of polarization in the society. The key demand was identity-based federalism, because the marginalized group thought that is the panacea for the years of exclusion they have been facing, the more decentralized government through federalism. But whereas the polarization between the status quo, those who did not want to give up the power, and the polarization between the elite, the status quoist, and the marginalized group was interesting, because it took two constitution-making elections. The first one was not able to deliver the inclusive constitution. So it was rife with violent protest and lots of protests and contestations during the last 10 years of constitution making process. And some of the key reforms that were able to establish was proportional representation for women. For example, in the last 2017 election, the first federal election after the constitution of 2015, 40% quota was reserved for women. But interestingly, when it comes to implementation of this policy, although the 40% quota was given to women, most of the women ended up being elected in deputy positions rather than the mayor. For example, there were fewer number of mayors being elected in local governments, and then more deputy mayors were more women. And this factor, the inclusive policies is also affected by the political parties, the power equation, etc. Because when it came down to 2022 federal election, the percentage of women rather went down. The number of candidates, women representatives, went down. So it shows that just because it is written in the legal documents, be it constitution or any inclusive policy documents, it is up to the social movements or civil society who are driving the social movements to hold the governments accountable, or the institutions, legal institutions, accountable to give to keep this inclusive policy alive, or to give life to this inclusive policy alive. And I will now move towards some of the example as my time is running out. For example, one of the example from indigenous movement, how they are doing it is, for example, For example, Nepal is a signatory nation to talk about ecological reforms, signatory nation to both Paris Climate Agreement and CBD. But marginalized community, their social movements are helping the national policy making to give light of intersectionality, calling the government and policymaker that is not enough. For example, Nepal is a champion in community forest movement, and but indigenous communities are calling it to look it from an intersectional lens, because they are the owners of the customary traditional indigenous languages, which are not adopted while policy making, national policy making, be it of community forestry or other related policies that affects indigenous people or Dalit people, Dalit community. So these civil society movements are bringing the more intersectionality lens to the broader policymaking, including in the constitutions, and demanding both at local level and also advocating at UN level to give recommendations to government of Nepal. Another example how it is being done is recently in summer of 2021, indigenous movement of Nepal was able to win the case against the European Development Bank against the building of this high voltage power line funded by European Development Bank, and they won the case against them. So it doesn't always have to be political movement, because political movement may die out because of co-optation or wariness of being involved, or because of influence of political parties and various reasons. But actually, environmental and ecological movement is also playing a key role to give space to marginalized movement in Nepal to establish their rights, or to fight against discrimination or marginalization. So the argument in this paper from the ecological perspective is that the ongoing climate change movement, which is becoming more stronger, and ecological movement in Nepal is also giving power to the political movement of marginalized people. So the movements can die in one form because state being more like regressive, then the environmental and ecological movement or the space would give more would be the another avenue for this movement to emerge.
Thank you so much, Alina. Sorry, I have to cut you off here, but I think people also want to read the paper and discover more examples. I think this was a really good overview of the main arguments. So thank you so much. And I think, please read the paper because it has many more examples and very interesting arguments. So I would really like to thank Alina and Gabriele for sharing that. And it was also discussed and, contributed to in the working group on historical injustice of the network. So thank you for that work and for presenting it, Alina. Many, many thanks. I would like now to give the floor to Justice Bhattarai, who has done his postdoctoral studies in the Max Planck Institute in Heidelberg. So I'll talk to him in German later. Willkommen. And he also has done his PhD with a focus on environment and human rights, as well as constitutional law. So I think he's a perfect practitioner to talk a little bit about the implementation challenges, because I think Alina already explained how, maybe the human rights movements have now been replaced by or complemented by environmental and climate change movements. So the actors might change, but I think the interlinkages between environment and social issues is still very strong. Really, really welcome, Justice Bhattarai, to talk a bit about implementation challenges of this very progressive constitution. Welcome.
Thank you so much. Good morning, good afternoon, good evening, fellow panelists, and dear listeners, wherever you are. It's my pleasure to be part of this high-level discussion. Elena has made my job very easy. She has touched upon many areas which are very deeply contested in Nepal. I would like to see the issues from the constitution making and what has happened afterwards, and how these issues have come to the court and how the court has tried to handle these issues. To those who are not very familiar with the Nepali constitution, I would like to state that Nepali constitution gives scope and space to civil society organizations to file public interest petitions in the court. Though, as a student of law, court is not always the right forum when we lobby for policy reform. But it is an important institution which provides legitimacy and also issues policy directives to the government to change the situation and work for better livelihood of the people. I would go from what Elena touched upon. Present here a recently decided case by the Supreme Court of Nepal. As you know, Nepal is a Himalayan country, and the southern outpost of the Himalaya system is the Churia region. This is a very fragile ecosystem, but in recent times, there so much destruction has happened to the Churia and the river system flowing from Churia and other areas. So jeopardizing lives of almost 50% of the people who live in the southern belt of Nepal. The idea, what has happened there is to excavate sand and gravels and export to India. This case was brought by civil society organization called ProPublic and a lot of other people to the Supreme Court. And recently we have issued a decision banning all the export of gravels and sand mining products to India. And we are looking very eagerly that the government implements that. Let's see what happens. Another interesting case that was filed by civil society organization to the Supreme Court was the construction of a huge airport in the southern belt of Nepal, trying to decimate almost 8,000 hectares of tropical forest. When this matter was brought to the Supreme Court, and Supreme Court looked into the environmental impact assessment done by very illustrious people. But what turned out was it was a fake cut and paste EIA assessment report. Therefore, the Supreme Court quashed the decision of the government to construct airport, which was expanded to the tropical, subtropical forest of the Tarai region, and asked the government to look for less destructive approaches and alternatives. These are just two cases, and there are many cases which have come to the Supreme Court. It is one terrain where rights of the people are raised when they are violated, and efforts are made to realize the constitutionally stipulated rights. Azabili Camp, you were interested to know, and I believe many listeners are, what has happened after 2015 when the constitution was promulgated. One big issue that affects almost all the Nepalis is political instability in the country. After the constitution was promulgated, elections were held, and people gave a clear majority to the party and coalition. But the government could not go for 5 years, and the dissolution of the parliament was made twice, not just once. On both the occasions, the court intervened and resurrected the parliament, and thankfully, parliament completed its 5-year tenure, and now the elections are being held. We are waiting for the results. So the court intervened for to give lease of life to the legislature, and legislature, whose primary function was to enact laws. And as you know, we have very expansive framework of fundamental rights, and where these rights can be operationalized only when you have parliamentary enactment and sufficient funding for the realization of rights. These issues could have been prioritized by the parliament. But by the end of the 5 years term, there was a press communique coming from the parliament saying, we enacted 30 laws. Oh, 30 laws, 30 acts within a scope of 5 years. One would be really disappointed to know that. And frequent elections in a small country and consumes a lot of resources, which could otherwise could have been very wisely spent on people's concerns, their livelihood improvement, health right, educational rights, and other rights. So these are the situation. But as I see as a sitting judge, Nepali constitution is progressive constitutions. One may not be very satisfied with what has been there, stipulated there, because there is always rooms for improvement. I also agree that it's a very costly constitution. I keep on telling people that if so much is is spent on meeting the needs of what you call superstructures, very huge parliament, and the state government and machinery, and so many constitutional bodies, which could have been made very cost effective. That has not happened, and cost wise, it's a very costly constitution. What happens as a judge, I'm not very sure, but what I am sure is that there are alternatives, less costly alternatives, and more money could be saved for improving livelihood of people and helping people to realize rights. This is one area that I would like to touch upon. Coming to the protection of environment and the effect of climate change, you know, we are in a very ecologically and geographically sensitive area, and Nepal has contributed very less to the green in terms of emission of greenhouse gases, but we are adversely affected. A lot of cases are brought to the court relating to the inaction and non-action of the government. For instance, PIL, public interest petitions were filed by flood-affected people. Public interest petitions were filed, women group, against domestic violence. Public interest petitions were filed on behalf of indentured laborers called haliyas in Nepal. A lot of issues are brought to the court, and court has handed down decisions directing government to act responsibly and accountably. And these are the things that I would like to flag up at the moment, and I'll wait for the questions and comments from the floor. Thank you.
Thank you so much, Justice Bhattarai. I think that was really interesting, and I think also interesting that you can see things that we often as researchers don't think about, like, for example, the costs of democracy and democratic institutions, and that it's also costly, like litigations, of course, you know, and it's often more costly to defend people's rights than one should think. And I think this is a really good kind of moment also or topic to pass over to Pedro. Pedro Cisterna, who is joining us. Thank you so much, Pedro. Bienvenido. And we are really happy that you are here with us. Pedro is a Chilean lawyer who has done his master's on environment and climate change law at the University of Edinburgh, where he is also doing his PhD now. And he's really focusing on, you know, vulnerable urban populations and, you know, the resilience to climate change. And he also works on a number of global and regional networks, on a network on human rights and the environment, and then also on a global network of peer reviewers on climate litigation. I think this is really interesting, this experience. And he's also, you know, heading this organization, Nuestra América Verde, on environmental issues. So Pedro, we're very happy to have you with us. And you will talk a little bit about the ecological kind of changes that the new constitution was including, and also the backlash against those. So yeah, you have the floor, Pedro.
Well, thank you, Isabel, for the presentation, and thank you for the invitation to this interesting webinar. And it's very, thank you for the previous presentations as well, because I think it frames a little bit, very good the discussion, and it is very interesting as well how there are sure like experiences in different countries, in different continents, but with very similar challenges. So basically, I would like to explain a little bit about the process of the constitutional process in Chile that happened. Then I will talk about, yes, some illustrations of how this the constitutional draft was very progressive in terms of climate and environmental clauses, and then explain some lessons of this backlash. So basically, after massive protests in 2019 against the government of Sebastián Piñera, these were spurred mainly by the severe inequality in the country, in Chile. So after this massive protest, huge violence as well in all the territory, but at the same time, huge repression from the police forces. The situation was so tense that the political parties basically agreed to reform the 1980 constitution, which was drafted by Pinochet in the dictatorship. And on the 5th of October, and they agreed to call a referendum for a constitutional referendum. And on the 5th of October of 2020, around 80% of the Chilean voters supported a new constitutional process, which was led by a popularly elected constitutional convention, which is kind of a constitutional assembly. So basically, this constitutional convention had the duty to prepare a draft, and they started to work in March 2021. So since the beginning of the work of the Constitutional Convention, the members of the convention tried to incorporate some ecological perspective, provisions, and even in the beginning, regarding the procedural rules of the convention, they, for example, approved a declaration that the convention was taking place within the context of an ecological and climate emergency, and also in the procedural rules of the Constitutional Convention, there were some principles highlighted, such as the respect and carefulness of nature, and also the application of an ecological focus across the discussion, and the principle of a sociological perspective, which basically were purporting to reinforce the interaction between nature and humans and understanding social processes interconnected with ecosystems and nature. And also, basically, what these procedural rules reflect is the intention to have a discussion using ecological lens. So this, since the beginning of the plenaries, there was like a huge consideration of environmental and climate aspects in the draft, and also having in mind that this, for example, in terms of climate change, the most vulnerable populations to climate change in Chile will be and are the poorest ones. So in the context of severe inequality, that severe inequality also is represented by the effects and the impacts of climate change in our country. So in this context, there was an environment within the Constitutional Convention. There was an environmental commission, and this environmental commission made a draft, and some of the rules were approved, some other ones were not. But the good thing was that the approved rules by the Constitutional Convention to be included in the draft were very substantive, and it changed completely the scenario of the Chilean legislation and the Chilean legal framework. So one of the first things was that the constitutional draft recognized the right to healthy environment, and this clause constitutes a substantial change compared to the current constitutional rule, the 1980 constitutional rule that recognized environmental rights, because the current constitutional rule only recognized the right to live in an environment without pollution. And an important difference there is that between that the existing constitution established a negative obligation not to pollute, but now in the new constitution, in the constitutional draft that was rejected, the Chilean environmental law basically recognized the right to environment as a positive right, so obliging the state to act, not to not act. So there were also plenty of rules that, especially in Chapter 3 of the constitutional draft, where there were the ecological aspect was very highlighted by obliging the state to adopt an ecologically responsible administration in Article 127. Also, the constitutional draft recognize the right of nature as a vital step for protecting the planet life support systems. So those are very progressive rules, and in addition, the constitutional draft mandates the state to adopt prevention, adaptation, and mitigation measures to tackle risk and vulnerabilities produced by the climate and ecological crisis. So this draft was actually, in case of approval, will have been the first constitution in using the term ecological climate crisis. So there were plenty of positive aspects of this draft. That, well, the question that appears is why this was rejected. It was so important and means like huge progress in terms of protecting ecosystems, but also protecting the most vulnerable populations to the effects of climate change and to the effect of pollution. Well, the constitutional draft was rejected by almost 63% of the population. So I would like to raise some points here, and this obviously is a continuous debate. So I don't know if there are like some lessons agreed, but this is my impression only. So I want to clarify that. So first of all, the first constitutional referendum was based on a voluntary vote. So the people who wanted to go on vote went, but when we vote for approving or rejecting the draft, the vote was compulsory. So that created a huge difference between the people who vote in the first instance and in the second instance. Actually, the first instance were like almost 6 million, and in the second 7 million, and in the second in the vote for approving or rejecting the draft, 13 million voters participated. So it's a huge difference there. And then there were some things in the process. I think one of the elements is that, or our lessons that we can consider is like, it is important to like the constant involvement of citizens. In my opinion, at some point, the discussion of the Constitutional Convention was quite distant from the social debate. So at the beginning, they were very close, but then the distance was expanding a little bit. So the reality that the Constitutional Convention was reading in the context in the Chilean context was quite different. That the reality that the citizens were living at some point. So that makes some progressive clauses that were contained in the constitutional draft quite difficult to explain, and this is also related to the climate and environment. What is really or maybe one of the biggest lessons from my perspective in climate and environmental rules is that it is very important to facilitate the understanding of these debates, because sometimes it's too elitist, and make these constitutional clauses more tangible. So basically, to convey the impact that these clauses, the approval or rejection of these clauses, can have in the people's lives. So I think there is also another challenge for a future process. And as Isabel asked me at the beginning, was, well, fake news were also a factor, definitely. But this was also, I mean, for a new process, we need to try to prevent fake news. That is very difficult. They were like fake news regarding the indigenous right, for example, that the indigenous citizens will have more rights than the Chilean citizens. So that was very spread amongst the Chilean population, which was a fake news. But there were plenty of topics to be discussed in the constitutional draft that the doors open for fake news were plenty as well. So that was, I mean, the constitutional draft had almost 400 articles. So basically 400 possibilities of spreading fake news for those who wanted to reject the project. So that is something to consider as well. And the last point I would like to make is that given the polarization of the country, given that this constitutional process was after a huge polarization of the country, maybe get broader political agreements in the constitutional draft will have been more useful for the approval. And I think I vote for approval of the constitution, but I think the context of the protest in 2019 gave a little perspective of what was the real situation, and this real situation changed from 2019 to 2021 after the pandemic. The perception of the citizens were different. So at some point, maybe broader political agreements with more trade-offs in some constitutional clauses will have been more useful for maybe it's quite a pragmatic view, but probably that the constitutional draft will be approved in that case. But I don't know. Now the constitution discussion is ongoing, so we will see, and I'm happy to answer more questions about the current context right now in Chile.
Thank you so much, Pedro. I think that was really also very interesting to hear a case where it has not been approved and the discussion is still continuing, and what were the reasons. So thank you. I think very insightful. So I would like now to open the debate. We have asked you to put your questions into the Q&A. And I would like to start with the ones that were received. There are two questions regarding a little bit more generally the vision for Nepal. What are the kind of the projects as a vision for society? Is it gonna focus on its sustainable use of natural resources, tourism? Where do you see kind of the vision of the society and the government going? That was one question. And then we will link that to a question about books to learn more about Nepalese society, because as someone going for a field trip to Nepal, so I think that would be like one going together. Then also there were questions about criminalization in the chat of activists. How do you deal with that? I think especially as a justice in the Supreme Court, I think would be interesting to see when activists are being accused of criminal acts. How do you deal with that? How can you protect activists? Then there were also questions about, from Gabriella a little bit, how do you, as civil society, move from different roles, from litigation to street protests, when is the right move, the right time to take legal action, when is the right time to take to the streets, etc. What would be your recommendation there? Then there is another questions also from Gabriella on, do you think that the recent UN resolution on the right to clean and healthy environment will have influence on the debate in Chile and in Nepal? So how does the international context influence the national context? Can you use these kind of resolutions, and how? Also, I think a very interesting question. And then we have another question here. So then he said, which of the ecologically focused, that's for Pedro, clauses were most or least popular in the end, and were they unexpected? I think very interesting also. And is it necessary for reform to take place as a result of repression and violence? Are we not civic and not enough to do so proactively? And then again from Katja on Chile, what are ways to create a broader consensus for the ecological and gender objectives in the constitution in the next round? Yeah, so I think let's start with those and then see whether we have time. Yeah. So the questions, are on Nepal a bit more in general, then also criminalization of activists, and then Pedro, as you saw, what can we do next time to have more support for gender and ecological questions? So maybe we'll start in the same order. Alina, then the Justice Bata, and then Pedro. Alina, please.
Thank you for the questions. Perhaps I could answer some of them, only a few. So for the question from Gabriele on adoption of recognition of right to clean and healthy environment, I can see from activist lens and as a human rights worker, working together with National Human Rights Commission, in addition to the civil society work that are being done at national level, could be another key strategy for both climate change and environmental movement and human rights movement to come together to make the environmental movement more stronger. And I also saw another question regarding the case of indigenous people winning case against European Development Bank, how it is important to adopt indigenous knowledge for protection of environment. Was this the core plea of community? For this particular case, it was different because it was rather focused against, as in protests against, and in a case against the neoliberal projects that the country signs with the ADB, World Develop, part of like ADB, World Bank, or European Development Bank, those multilateral banks. So not for this project exactly, but for our overall demand of the moment is, yes, indigenous knowledge should be there and is key for protection of environment, because even if the environmental policies are made at national level, for example, community forest protection measures, they are based on local indigenous knowledge, but they are not giving it the credit to the custodian, those are indigenous people, in a policy level. So although the measures are being adopted in policy, the credits, it's not being given. So this is one of the core plea of the indigenous peoples movement. Yeah, perhaps, and there is, opposition, why the people were so opposed to the new constitution in Nepal. So not all the people, mostly the marginalized group, and from the plain south, because as I said earlier, the key demand of constitution was federalism based on identity, and the status quo group, or the elites, or the non-indigenous group thought that could be disintegrate the society, or it's against the national unity. So these were some of the key prospects from both sides. To answer that question very briefly now, although it has larger other implications. Yeah, thank you.
Thank you very much.
Thank you.
Yeah, Justice Bhattarai, please.
Thank you. Thank you for showing interest on Nepal and asking a couple of questions. I'll concentrate on environmental front. Since we are talking about eco-social contract, the Constitution has very emphatically stated that people are sovereign and are the source of sovereign power and state authority. And they are the people have given the Constitution. So it opens up bottom-up approach to the political conduct and socioeconomic conduct of the state. A lot of legal dictums earlier adopted are changing. For instance, power of eminent domain of the state is now supplemented by the principle of public trust. State is not a machinery which can do anything to people, public interest and concern. It is bound to respect public interest. So it is a trustee of the faith of the people, rights of the people. Secondly, in Nepal, the discourse has opened on horizontal implementation of rights. Ms. Camp, you'll certainly relish to know that what you call in Germany the radiant effect of right. So it's not only the state which violates right, it is corporations and other social groups also violate rights. So an eye has to be, a watch has to be kept on their activities. And when rights are violated, state has a bounden duty to protect and respect rights. This is also coming up in the constitutional and legal discourse in Nepal. And coming to the UN Declaration on Clean and Healthy Environment, Nepali Constitution has Nepali Constitution embodies right to a clean and healthy environment in a more stronger terms. For instance, it also guarantees rights of the victims of environmental degradation or right to claim compensation. It requires the state to make a proper balance between development and protection of environment. And there are a lot of, as right to live with human dignity is considered most fundamental among fundamental rights in democratic world. Similarly, right to a environmentally sustainable development is also considered as one of the most fundamental rights. Therefore, a balance has to be made between environmental protection and development. And a new meaning has to be unearthed regarding development. Does development mean only a project, or is it is a process where people participate in decision making and benefit sharing? These are the concerns people have raised, especially the civil society, and cases are brought to the court. And court has tried to find answer to those questions. Coming to the importance of the decision, UN General Assembly resolution, it will certainly have impact on Nepal, especially not only Nepal, especially the capacity of developing countries and environmentally very vulnerable countries to raise their voice at the international fora and make a dent on make a claim, legitimate claim on the need to compensate what they have been, what has affected them so much. One more question that is been asked about the criminal action against activists. There are sporadic cases where environmental defenders are even in one or two cases they have been killed, and criminal law of the country has taken a course, and hopefully the victim's family, the culprit will be punished, because this is a ongoing case. I don't want to speculate on that, but the legal process has taken up. And I believe that after the decision of the Supreme Court to ban export of sand mining and gravel mining to India, a lot of things will come to normalcy. I would like to stop here. Thank you.
Thank you so much, Justice Pedra. I think that's also very insightful, and yeah, a lot of interesting cases, to illustrate what we're talking about. And Pedro, would you like? You got a lot of. You've seen in the question answer. You got quite a lot of questions. So please, yeah.
Yeah, thank you. Well, there are a couple of that. So first about the UN resolution. Well, while the constitutional draft, the Chilean constitutional draft was written, this was recognized by the UN. So this resolution. So obviously, it had a positive impact, and I think it will have a positive impact in the future. I think this is a right that probably will be part of the potential new constitution in Chile in the future. So regarding how to make a broader consensus, that is not easy. Chile is a country, and probably is the situation of many countries, where there is a huge, I mean, there are important political forces from the from conservatism and opposed to any structural change. So I think the best way to create this broader political consensus is by basically engage people in these demands. And I think plenty of the demands that are on the clauses that the constitutional draft had, such as the ecological or the indigenous rights ones, or the were quite not felt by the majority of the people, but not because they were opposed to it, but mostly because they didn't know about the population wasn't aware about the impacts or the content of these constitutional provisions. So I think that is also a topic, and that is related to another question about the factors. What were the factors why the constitutional draft was rejected? And I think Maria mentioned multiculturalism. Well, actually, that was a huge debate, because basically what the constitutional draft used was the concept of plurinationality, which is different as to multiculturalism. And plurinationality was very difficult to explain to the citizens, because basically, and that was a huge source of fake news. Plurinationality basically means to recognize different nations in one state, which was the purpose of the Chilean constitutional draft. However, what the fake news were spreading was that we will have like different nations, what will be different territories. So the people who vote against the plurinationality because they didn't want to basically divide the country. And so the plurinationality concept, which I understand and I support, because it has like very Latin American, it has a Latin American origins, like Boaventura dos Santos was the creator of that concept, but it was very difficult to explain, because you had to explain what is a state, what is a nation, what is many different nations in one state. So in a political campaign, that is very difficult to explain and to convince people. So sometimes I think, and this is a personal view, in these complex referendums and processes, maybe it's better to be pragmatic and also to understand the situation of the cultural situation of the population, and not because they are ignorant, no, because sometimes there are concepts that even for educated people are complex. So maybe simplify the discussion and go for. So I think, and those details are the ones that those who want to spread fake news use to put fear in the votes of people. So I think that is a really relevant point, and I think this ongoing process in Chile, well, now it's quite difficult because of the far right and the right wing. It's very well, they are very entitled right now with the result of the referendum. So basically, they were some of the Chilean people rejected the Chilean draft, the constitutional draft, because they were from the far right and the right wing. But also there were plenty of people who rejected the constitutional draft because they didn't understand some clauses, or they didn't agree with some of the clauses. And I think there is another opportunity that we have to get broader political agreements, but also simplify the debates and make the concepts more understandable for the people who vote, for the voters, for the citizens, and have a constant debate about that. The connection between the organ who is writing the constitution, which is writing the constitution, and the citizens should be permanent or not, because otherwise you open the door for fake news and lies. So yeah, that's basically.
Thank you so much, Pedro, and to also Alina and Justice for raising very interesting answers. And then please also read the thematic brief where we have put it several times into the chat on Nepal and the role of rights-based activism. I think it's really worth reading, and it will answer many of your questions. And I think, also in answering and trying to summarize a little bit the debate, someone said, oh, can you have new visions for new eco-social contracts only as a result of violence and conflict? I think there are many, I think it's definitely part of a rupture, because without a rupture, there is no space also to come up with new visions. And you need to have that space where people can participate and discuss and bring in their grievances and new concepts. But I think there are examples of peaceful processes where that happened. I mean, think of South Africa. Of course, it was after a very violent apartheid system, but still, you know, it happened without civil war, and a very participatory process resulting in a very progressive constitution. Happened in Kenya, 2010 new constitution in Kenya is very progressive. And, you know, I was able, because I lived there, to follow the process, a lot of civil society mobilization based on human rights, very interesting process without kind of a violent conflict before. And I think it's this kind of creation of that space that allows, you know, civil society to come in and participate, or because they were fighting for that space, I mean, depending on the situation, that this can happen. But I think it's a really unique opportunity as a citizen also to participate in such a process where you can really be part of, you know, envisioning a new society, a more just and more ecological society. So I think that's also what we would like to support with the network, and, you know, through the exchange of different experiences on new eco-social visions and constitutions. And then I think very interestingly what, you know, the Justice Batarai said about, you know, what is really what does meaningful participation mean? Does it mean freer, prior, informed consent? Does it include benefit sharing from natural resources? So I think this participation, to be meaningful, you know, needs a lot of kind of resources. It needs public space, and then, as he also said, even the implementation of a constitution is costly, you know, because you have to pay for the courts, you have to, you know, pay for the implementations, for grievances mechanisms. So it's a really interesting, it's not that you have the constitution and then everything is done. No, it's really also about keeping the momentum for the implementation and learning, you know, from mistakes. I think that's also very interesting. And then also what Pedro said, the importance to have clear concepts and have the buy-in of people for these concepts. Because that can really lead to rejection if people don't understand, or, you know, or are not clear what they're proposing. So there has to be a common understanding of the common good that you want to see reflected in a constitution. So I think the idea of a common good, you know, that you want to achieve through the constitution is really, really important, and so that different people can really feel and identify with that vision. So I think these were two very interesting examples from Nepal and from Chile, and I would really like to thank the panelists for, you know, sharing their experience and their with us, with all the participants. And I would also like to invite all of you. We have now at 3:30 German time, we have the network meeting of the Global Research and Action Network for a New Eco-Social Contract, where we kind of want to discuss, you know, what has been interesting so far in the network, how can we improve the network. But I think these kind of webinars and exchanges is really kind of, you know, it's really important for us. And as we said, we also stand ready to support, you know, future processes. And I think this international advocacy or networking around these processes, including the Chilean constitution, are really important advocacy tools. So thank you so much. And yeah, see some of you at 3:30 for the network meeting. And to all the others, have a really, really good week. And thanks for joining this